And we have the composite, we have the mugshots, we have the lineup. And take a look at it yourself, because that's an important part of it. Now, the reality is, every white person who's ever seen the two, and there's a picture of the two of them together in prison, because there's another story about that, side by side, and every white person I've ever talked to has said, oh my God, they look crazy similar. Every African American that I've ever talked to has said, they don't look anything alike. Nothing. That bears in this whole cross-racial ID concept of how races are particularly bad, which is bad. I used to think it was just white people stunk at this. I just thought, well, white people just don't know. And then I started realizing that it's actually, every race is very, very bad at being able to identify features of any other race. So that becomes a complicated, you know, and Jen is going to talk a little bit more about that today too. But the guards used to get them confused in prison. Used to call pool cotton and cotton pool. And Ron was brilliant enough to recognize Bobby Poole in prison and said, and this is in the book too, where Ron looks at Bobby Poole coming into prison and says, my God, that guy looks just like the composite sketch. And went up to Bobby Poole and said, did you commit these rapes? He was like, no, I didn't do that. And then, of course, one of his buddies, you know, snitches on him and tells Ron he actually did confess. Ronald becomes quite intelligent and has a picture done in prison of the two of them together, saying, hey, Bobby Poole wanted to write one of Ron's sisters. And he said, hey, I'll send the picture to my sister. And if she thinks you're, you know, attractive, she'll write you. So he sends it to his defense attorney and says, this is the guy. Like, this is the guy who did it, which is how Bobby Poole ever became a suspect. So, but it's an interesting phenomenon. It's something, I mean, I would really encourage you to look at these pictures online. And if you just want to buy the book, buy it, you know? So, and I'm going to take this question up front real quick.
Yeah, doesn't that in some way serve a function? Because it was a likeness, and the question is, if someone's out there, law enforcement is trying to find this person, what are the means would there be to find this person, except to have a likeness, at least that gives them a clue?
Mm-hmm. So, and I had this question last week in Hartford, so I will tell you that the likeness was really crazy good. But I think composite sketches are awful. And I'm actually a supporter of not having composite sketches because there's so many exonerations that we've dealt with where the person becomes a suspect because his ex-wife or ex-girlfriend or the cousin that he, you know, didn't pay back a loan from is pissed off, and they pick up the phone and go, my God, that composite sketch looks like my ex-boyfriend, and man, he's bad, and you know what, he told me. So I think composite sketches lead people down a path that we don't really necessarily want to go. Yes, my composite sketch happened to be really good, but most of them could look like anybody in this room. And oftentimes, and police officers I'm sure will know this, lead an officer down a path that you know, that's time being used from an officer on someone who was at work or, you know, somebody who has an alibi. So I really don't like composite sketches, and I think we should do away with them. But I'm going to be around today, so if you have any questions, I'll be around and you can come and pick my brain. So thank you so much for being here.
Our first group of presenters is our district attorney panel. Jeff Rosen has been with the Santa Clara District Attorney's Office since 1995 and became the elected district attorney in 2011. His county adopted a set of uniform identification policies in 2003 that includes blind sequential presentation of lineups, so he has quite a long history with these practices. Our next panelist is George Gascon, who became San Francisco District Attorney in 2011. He previously served as Chief of the San Francisco Police Department, Assistant Chief of the LAPD, and as Chief of the Mesa, Arizona Police Department. Nancy O'Malley is the first female District Attorney of Alameda County and has served that office in a variety of leadership positions since joining the office in 1984. You've already been introduced to the Executive Director of the Northern California Innocence Project, David Onick, who will moderate the panel.
Thank you very much, Maitreya. And as I said at the opening, we are just thrilled to have this panel here. These are 3 district attorneys who are throwing true leadership in bringing best practices to their departments. These are practices that are going to spread more and more, and they are at the vanguard of it. So we are very grateful for their service and delighted that they're all able to be with us today. George Gascon, unfortunately, the Board of Supervisors in San Francisco is having a budget hearing right now, and the district attorney is about to be called before the Board of Supervisors. For any of you who have been before a budget committee, it is not a pleasant experience. So we are going to let DA Gascon go first. He will say some remarks, and then unfortunately we'll have to take off to go to the Board of Supervisors, and then we will continue with the panel, and our other 2 panelists will be available for Q&A at the end. So George, we really appreciate that you squeezed us in on a very busy day.
Thank you, David, and good morning, everyone. And Jeff and Nancy, you guys are great partners in this. Okay. Can you hear me? Is it working? Nope. I think it's on. Okay. How about now? We got it? Okay, great. Thanks, David, so much. And Jeff and Nancy, you guys are great partners in this area. Believe me, I'd much rather stay here today than go to a budget hearing. But given that they're asking us to give back and we continue to lose ground when it comes to resources, I think is really a priority for us to be there. But it's really, it's an honor being here this morning and sharing this, the table here at the front. This is an area that has the potential for tremendous improvement within the criminal justice system. I think that for many years, and I will, be out there and admit that for many years we thought that, single witness identification was okay. And especially for those of us that have been in the business for a long time, like I have, about 3 decades, we did business regularly with single witness ID, and quite frankly, I felt very comfortable. People would identify someone, and we saw that it was a credible person, and we moved forward and conducted a lot of investigations and certainly a lot of prosecutions based on that. I think that today, though, we have come to realize that probably a lot of the things that we were doing 20, 30 years ago were not necessarily best practices, and as we have evolved, we have learned that not necessarily because people are trying to be misleading, just the way that our brain works and the way that we retain information or gather information and process information internally, just having one person identify a particular individual with no corroborating evidence is probably not the way to go any longer. So I am, very proud of, number one, the fact that San Francisco has Alameda and Santa Clara were, leading the way in this area. Very proud of the fact that our police department now has sequential show-ups and blind show-ups, which I think is so important. And I tell you, in my own office, we not only look for that, but frankly, we will not, we look in cases when we have a single witness identification, we're consistently looking for corroborating evidence before we move forward because we understand the deficiencies that come from just one person observing something and believe that what they did see is actually what happened. So I'm very proud of the fact that we're not only doing this in San Francisco, but this is a way of business that is moving around the Bay Area. And I look forward to the day when this will be the norm. I'm also very, I have to tell you that, one of the things that I do for my prosecutors is that I, before you can become a district attorney in my office or investigator, we have you see the Innocence Project video on, After Innocence, because I think it's a very revealing video about, what happens when we make mistakes in the systems. And I'm not even going into necessarily any type of misconduct or intentional behavior by anyone in the process. Just simply, we're human beings, and when human beings are dealing with things, sometimes there are mistakes. And when we're dealing with the lives of people, and when we're talking about incarcerating people or for, for extended periods of time, some in many cases, or impacting the ability of someone to have employment or housing. I think that we have to put checks and balances, and we have to make sure that what we're doing makes sense. And again, I'm not necessarily talking about any kind of misconduct by anyone in the system. I think that will happen sometimes, but again, when that happens, I think that we generally have ways to deal with that. But just when people are acting in good faith, trying to do the right thing, but just the infirmities in being a human being. So I'm very glad that this is going on today. I thank the Northern California Innocent Project for all the work that you guys do, David, and certainly it's an honor being with you, Nancy, and Jeff, and I really apologize that I'm going to have to cut off, but if not, I may lose people, and I don't want to do that, because then we would have a harder time prosecuting cases. So thank you so much, and have a great day, and I look forward to hearing what you guys have done today.
Thank you so much, George. Okay, we are next going to hear from Jeff Rosen. Santa Clara has been using the best practices we're talking about for over a decade now, and he will offer some reflections.
George Gascon is so rude. So it's important to understand. Not on, Jeff. It's not on? Steve, I can hear you fine.
You're on now.
It's on now? No.
Here. Here, Jeff, just use mine.
You can use that one. So, good morning, everyone. I think it's important to have a little perspective or an overview of what the mission of a prosecutor is. And even for those that are familiar with what that mission is, whether they're in law enforcement or work in the criminal justice system, it's important to restate it, because things that we repeat them because they are important. So the mission of the district attorney's office, really of any good district attorney's office, is to vigorously pursue justice, vigorously, but to pursue justice in a way that's fair and treats everyone equally and with respect. So to pursue justice justly, that's the fundamental mission of a district attorney's office. And there are no shortcuts in doing that. Of course, the fundamental mission of a defense attorney or a public defender is to vigorously represent the accused, to vigorously defend the accused. And often, the mission of the defense attorney and the mission of the prosecutor put us in conflict. And that's the nature of our adversarial system. And while our adversarial system, right, we have a prosecutor, we have a defense attorney, and they go at it, they battle. Now, while that adversarial system may be good for figuring out what happened in a particular case, was there a crime committed, who committed it, while it may be good for that, it's not necessarily good for building a future or for building best practices. Now, what I mean by that is, as a prosecutor, I've had many cases where I'm battling with the defense attorney over the value of an eyewitness identification. And, we're arguing to the jury that this has a lot of value and the jury should take this, should give great weight to this, and the defense is arguing this is a bad lineup, there's all kinds of problems with it, and it should be disregarded. Now, that's sort of looking backwards. And the reason that I created a conviction integrity unit in our district attorney's office is to try to look towards the future and build better practices going forward. So the unit within our office is called a conviction integrity unit purposely. It's not called an innocence project, although part of what our conviction integrity unit does is looks at old cases. We've exonerated several individuals the last few years, meaning we convicted them for crimes they hadn't committed. They were serving prison sentences, and we set those convictions aside. But we call this the conviction integrity unit because that word integrity has a couple meanings. Right? Integrity has a sense of high ethics, high moral standards, and also of strength, and wholeness. And what we're trying to do in our district attorney's office and many district attorney's offices is to strengthen the convictions that we have obtained, meaning to give the public even more confidence in their criminal justice system that we have convicted the guilty and only the guilty. So that's why we call this a conviction integrity unit. And within our office, as I say, it does two things. So one is it looks backwards. We get requests every month from defendants, from their attorneys, from families saying, look at this case that where you convicted this person, we don't think this person committed the crime, and we reinvestigate those cases as appropriate. Sometimes that involves DNA work, sometimes that involves re-interviewing witnesses. We look at all of those things, we take it seriously. The vast majority of time, it doesn't change that result. But there are a few occasions where it has. And just recently, you might have read in the paper, one person that we convicted about a decade ago for very serious crimes, rape, stranger rape. We realized we had the wrong person. He'd served a prison sentence for several years. We moved to set aside that conviction, and the state paid him $300,000 for the time he had spent in prison. And that was the basis of that wrongful conviction was mistaken identification. This person that we convicted had the extremely bad luck to look just like a serial rapist. And someone had asked a question about, well, we don't always have DNA in cases, and how can things be reinvestigated without that? This was a situation where it wasn't DNA. It was an example of someone that had committed rapes in multiple cities in our county, and unfortunately our local police departments were not able to put together that this was the same person, and we made a mistake, and we acknowledge that. So one of the things, conviction integrity unit, is it looks backwards in this way. But the other thing that it does that's maybe even more important is looking forward and looking at what are practices that will reduce the likelihood of wrongful conviction. So one of those areas is eyewitness identification, and it's been talked about a little bit by our previous speaker. Eyewitness identification is a high-risk area that does need improvement, and some of the reforms that we've instituted in our office are doing double-blind sequential lineups. So the reason we came to this decision, and we've been doing this since 2002, is, you know, we read, we look at the science, we look at the data. I think that in some sense, being in Silicon Valley, where our district attorney's office is, there's an openness to data and change and science and trying to do the best practices. And I would be remiss if I didn't say that I was blessed to have a group of police chiefs in my county that are very open to trying to doing something different if that's a better way to do it, and are not stuck in the mindset of, well, this is how we've done it for 20 or 25 years, and we're not going to change that. So that's just something that's been very fortunate. But really what led us to changing how we look at eyewitness identifications is there just were study after study showing that there's errors, that when you look back at wrongful convictions, and there's 300 so far DNA exonerations in our country, a lot of those cases, 70% of them, one piece in that led to that wrongful conviction, a significant piece, was a wrongful identification. And the thing about the way we were doing eyewitness IDs before is about 70% of the time, the witness or victim picked out the suspect, 70% of the time. 30% of the time, they picked out a filler. So, I don't know, it depends on how you look at that. If you were running a business and you had a 30% error rate, you'd be out of business very soon. So that's an error rate that we thought was very high. And we know that mistaken identification is a significant cause of wrongful conviction. So we started looking at what were some common sense reforms. So essentially what we do in our county, and I know we have some some of the chiefs from my county are here. They know this, and I know there's some police officers and police chiefs from other counties. But in terms of how we handle eyewitness ID, we have a written protocol for that. It's not something that we just leave to the officers to do unguided. We make every effort to use 5 valid fillers with only 1 suspect in each lineup. We admonish all the witnesses that the actual criminal may or may not be in the lineup, that it's essential to clear the innocent as well as convict the guilty, and that the investigation will continue irrespective of whether they pick someone out or not. And fourth, we use a blind administrator, or what's called double blind. So the detective that's running this investigation that knows who the suspect is not the person that shows the lineup to the individual, to the witness, or to the suspect, to try to take away any potential for subtle cues. Not even overt things, but things that are subtle or subliminal. And how did, in the Mr. Ed show, when they said to the horse, count to 5, and the horse, moved its hoof 5 times, well, gee, how did that happen? Well, there's certain cues that the trainer is giving, to stop at that point, and it's hard to control for those things. So we have a blind administrator do it, and finally we use a sequential process. So the photos shown 1 at a time rather than 6 at once. And the reason for that is what the science had told us is when you show 6 at a time, the witness is more likely thinking, which of these 6 looks the most like the person that committed this crime? Now that's an interesting question, but we're more interested in whether that person's there, not whether someone who looks like that person is there. So when you show the photos 1 at a time, the brain is more like this: not it, that's it, not it, as opposed to which of the 6 looks more like the person. And then finally we get 2 things. We get contemporaneous statements from the witnesses as to the strength or how they feel about this identification, how strongly they feel about it. And then finally, the thing that I think is most significant that we've done more recently is that we audio and videotape this interaction so that the officer that's showing the lineup to the witness, and this takes maybe 5 or 6 minutes to do, that whole process of showing the lineup, going through, seeing what the witness's reaction is audio and videotape so that we have an objective record of it. So that on the one hand, we can, as prosecutors, if the witness, they freeze up or they start to cry or they, oh my God, that's the man who did this, versus, well, yeah, I think that's the guy. All of those things are helpful to us in deciding whether to file charges, and it's important information for a jury to have. And lastly, I'll just say a word about our experience. So we've been doing this for more than 10 years. We haven't seen a significant increase in costs either to the law enforcement agencies or to the prosecutor's office. We haven't seen a significant decrease in the identifications that are made. We have seen an increase in the accuracy of the identifications that are made. And we've seen less defense use of eyewitness identification experts because we are using the gold standard for this, and we haven't had a single, since we've instituted this policy, we haven't had a single case overturned based on in any way a wrongful identification. So it's worked very well for us. We're going to continue to use it, and that's what we got.
Thank you very much, Jeff. Now we'll hear from DA Nancy O'Malley from Alameda County.
Thank you, David. Good morning, everyone. When I was reflecting on what I could add to this conversation today around this new process, or relatively new process for many, one of the things that I was reflecting on for myself is that my office has been producing the training tapes for post for a number of years. I mean, longer than I think I've been in the office, actually. And so that gives us a great opportunity to take a look at trends, take a look at new studies, take a look at promising practices, take a look at things that look like a promising practice, but when the research is done, maybe don't bear out to be so. And so when we first started paying attention, or I first started paying attention to the blind sequential lineup process, it was really about gathering information and reading the studies that Jeff just referred to, and looking at those critically to say, you know, what's the story? Is this, you know, people that don't want anyone convicted that's writing reports, or are these legitimate? And we found that, just as Jeff said, that there are a number of studies that have really endorsed this practice over the traditional practice of simultaneous photo display. And in looking at it critically, it also gave us the opportunity to take a look at the process that we are going to establish in Alameda County, because we wanted to create a process that law enforcement would follow, and that they were part of the design of our process. And we did that as well. The way our process began was that I looked a lot at what they were doing down in Santa Clara County, looked at all of the studies. Some of our chiefs, Chief McQuiston from Albany, Chief Ken James from Emeryville, were two leaders who had implemented this years before independently in their own department. So we started looking at how we could get all of our departments together. In my county, there are 24 different police agencies that I deal with. And we wanted to make sure that everyone was on the same page. And here's the number one reason why. Well, not the number one. The number one reason we wanted everything to be right, and we wanted to have the greatest amount of integrity in the process as we could build, understanding that we're all human beings. But the other reason was that if one department adopted double-blind sequential lineup and the others did not, then while the other departments might have done a completely valid lineup process with an accurate identification, that could then be used against them in court to try to undermine that valid work because other departments had adopted a new policy. So for me, it was critical that we all were doing the same thing, or all of our law enforcement agencies were. And I didn't want a case or witnesses to be unduly cross-examined just based on process and not on the integrity of the actual identification. So that was critical to get everybody on board. I started looking at this in about 2010. About 2011, our chiefs started talking about it. By 2012, we had a committee made up of mostly captains from each of our departments, and then I assigned two of my senior trial lawyers to the committee so that they were the legal advisors as we went through the literature and started to build our own protocol. Some of the studies, I just want to echo what Jeff was saying, that some of the studies have shown very interesting findings, and you heard a little bit from Ms. Thompson this morning, but the studies have shown, which we relied on, that simultaneous photo displays really encouraged relative judgment, meaning a witness could do photos side by side, take a look at it, see who looked the most, and then that psychological impact of now it's emblazoned in their brain that this is the person that they picked, and there's a little bit of, you know, people get entrenched in their position. And then if they then do a live lineup and the same person is there, now they've seen him twice, and if they do another, now they're in court and he's the only person sitting at counsel table with the lawyer. We just needed to make sure that we are doing everything right and that we are using the best practice. We also found through the studies that the blind sequential lineup really took out that not only the lineup itself of looking at each photo, if it's a photo lineup, each photograph separately and being able to look at that, not having any reaction by the person who's administering the lineup and continuing the lineup even though somebody might say, that's the guy, I know that's the guy, continuing the lineup. The other part of that was that the blind administrator was critical to the process because that person didn't know if the suspect was in the lineup or not. And so there wasn't the ability to even give a really subconscious or subtle cue to the witness who's obviously nervous, freaked out, you know, looking for somebody to give guidance, things like that. So, so we did start our path, and we created our protocol. There was no resistance from our law enforcement officials. We haven't seen resistance from the law enforcement officers. And one reason why I think that is because we undertook the task of making sure that every officer was trained and trained provided enough resources and training and knowledge and material so that he or she did not feel like they were being told to do something differently, and maybe subconsciously they could think this is because we were doing something wrong, which is not what adopting a new protocol is. And we didn't want people to try to fill in the blanks where they didn't know what to do. And we also wanted to make sure that, again, we were all doing it the same. So we actually, because we do all these training tapes, and we have a TV studio, and we created our own double-blind sequential training, which has simulated lineups and both photo lineups and in-person lineups, so that the officers could watch it on their own computer. They could get it from the internet through our own network. They had the DVD if they wanted. We show it. It's not so long that it's arduous for someone to watch. And if an officer has not been involved in conducting a lineup, either as the blind administrator or the officer requesting the lineup, that they could take a half an hour and watch the tape just to remind themselves, so that when they do go into the process, they know that they were equipped with all of the tools they needed to ensure the integrity of the lineup that they were either requesting or conducting. I think that the training component of adopting a new protocol is probably the key to its success and its utilization. And for that reason, a lot of what we did was spend time. The two senior DAs in my office went to every single department, worked with every officer, and that was, for me, critical to give that level of resource to our officers in the county to make sure that they knew that they knew what was going on and why and how to do it. The one other thing I will just echo with to what Jeff said was that there is actually a United States Supreme Court, U.S. versus Berger, which does identify the ethical obligation of prosecutors. And one of the ethical obligations of a prosecutor is to stay abreast of the law. And while these studies have been going on for quite some time, I think the refinement of the studies have really gelled in the last 5, 6, 7 years, where there's been a lot of critical process of evaluating and debate about it, so that we could settle on the validity and the importance of this as a best practice, not a promising practice, but a best practice. And that, again, leads, from my standpoint of working with the local law enforcement in my county, was critically important that we knew what best practices were, that we are abreast of the law, so that then we could pass that information on to the police who were putting those investigations together. And by the way, in my office, I have a department that has 65 sworn officers. And the police officers that work in my office are, and I'll just give you a little quick background. Earl Warren was the DA of Alameda County in the 1925s to 36. And at that time, there was a lot of police corruption, a lot of police graft. So he decided that he needed to have an elite police force that answered to the DA, who answered to the people and not to politicians. And so that's where the first investigator or inspector division was formed. And now virtually every office in the country does. So we take that very seriously. And at night when I'm at work, if the door blows open, I let Earl know that everything's under control. But I say that because the police officers that work in my office, the inspector division, are some of the finest officers from around. Most of them are from Alameda County law enforcement, but not all. And they all have been trained on this process also, because we expect those officers to be a resource for local law enforcement, working on not only as they're putting their investigations together, and as Oakland has worked to bring their law enforcement staffing levels up, we've become more involved in working side by side with the police officers in Oakland. So it's critically important that those people, the investigators and law enforcement in my office, know exactly what the process is, why, how to administer a lineup. And then a good portion of them, about 20 of them, do their own investigations. They do the original investigations. And lastly, every attorney, of course, has been trained on this process. And we share our training materials with our defense bar and our public defender to make sure that everybody's, and the judges, to make sure everyone's on the same page.
Terrific. Thanks a lot, Nancy. We're going to open it up for questions in a moment, and there'll be some microphones coming around. I just want to start with a question about risk management, because some of the calls we've gotten recently are from jurisdictions. Folks in charge of risk management in jurisdictions are really concerned if they're not doing the right thing, that there'll be large lawsuits against them, especially as the tide turns and this becomes more and more an established practice. To what extent did those concerns help you garner the political support you needed to make these changes? I'd be interested to hear both of you on that.
Well, I did not, that was not actually a factor in the adoption of this protocol by the chiefs. In fact, as I said, a couple of our chiefs had already implemented it in their own departments. So where there may have been a little gap in the discussion, those chiefs stepped forward and spoke to the issue as I raised it. I think having the Chiefs Association was able to mitigate any concerns that this was something other than just adopting a best practice. And you know, we haven't had the experience of having a wrongful identification result in a reversal of a conviction. And so the risk management component was less of a factor for me, and I think I hope for our chiefs. For me, the motivator was we want to do it right, and we want to make sure that for every single conviction that we do secure, that we can rely on the integrity of that conviction because of the integrity of the process. And where there was question about whether or not we actually had the right person, even if there was an identification, that we would step back, evaluate, and dismiss if need be, if we couldn't prove the case. And so,
yeah, I agree with essentially what Nancy said. I think the language that we use as prosecutors or those in law enforcement, I don't know that we talk so much, at least from a prosecutor's perspective, about risk management, but we think about things in the sense of what's the most professional way to do it, what's the best way to do it, what are the highest standards, and that's, I think, the way that we think about it. And then also, of course, coming from a place of recognizing that I think one of the worst things that could happen to a prosecutor is to convict somebody who's innocent. I mean, I just think it's devastating for that prosecutor. And so it's wanting to be able to say that we've done everything we could to make sure that we secured the conviction fairly, and that it has integrity, not just that it's going to stand up on appeal, but that this is the guy who did it.
Thanks. We're going to open it up for questions. I believe there's at least one or two microphones circulating. What about that one, Todd? Oh, okay. Okay. So raise your hands, and while they're coming around, I just want to make one quick comment before we start, which is that, you know, our office has worked very collaboratively with both Jeff's office and Nancy's office on exonerations, where we are actually working side by side, where we can go to either of their offices and say, you know, we have some concerns about this case, and they say, okay, show us what you got, and very open-mindedly work side by side with us. And we have had exonerations in both counties where we're standing side by side announcing the exoneration, and that kind of partnership is just amazing. We are incredibly appreciative and want to continue to be good partners going forward. Okay, let's start in the middle right there.
Hi, I'm wondering what, I'm concerned about the bias that attaches to the trial prosecutor once a conviction is secured. And I wonder, in your departments, what do you do, in what way do you involve the trial prosecutor at the post-conviction stage when you're reevaluating the integrity of the conviction?
If you want, you can take it off and just hand it back and forth. Oh, okay. There you go.
The answer is, in the cases in our office where there have been exonerations, we have involved the trial prosecutor. That's a person that's going to have a lot of knowledge about the particular case, about how the investigation proceeded, about how this person became the suspect, about how the evidence was collected. So the trial prosecutor is very much involved in that. And as you can imagine, that creates some difficulties, because our approach is not, we're looking at this to see if we have the right person because you screwed up, because you're evil, because you committed intentional misconduct. I mean, unless you did, but that's another issue. but things happen, mistakes are made. You know, when somebody dies at a hospital in a surgery, sometimes it's just, it's bad luck. It wasn't even negligence, it's just this is what happened. And yet, every hospital does a kind of post-mortem and a review to see if there's anything that could have been done differently to save this person. And that's how the mindset that we have to approach it. We want to have what we kind of think of as a safe harbor approach. If our approach is to say, oh, wait a minute, we think this is a wrongful conviction and we're immediately going to accuse the prosecutor of doing something wrong, you know, they're going to pull back, as opposed to, what happened? Were there any mistakes that were made? So in the cases that we've had, we've involved those individual prosecutors. And, you know, to be frank, in one case, the prosecutor was more open and understanding of what had happened. And in another case, the prosecutor wasn't. But at the end of the day, it's not about the feelings of the prosecutors. It's about justice. So that's the overriding concern.
So we had a situation recently where we let the trial prosecutor know that we were reevaluating a case, and so he and I had a private conversation with the prosecutor about that fact, so that whatever we were going to talk about was going to be, you know, respectful to him. But then I have a group of people that I brought together, and the trial prosecutor was not involved in that. And we basically had I mean, I knew what I felt, but I kept my mouth shut, and we had an open discussion with the top trial lawyers to say, let's evaluate this, and what do we think at the end? So we were our own blind administrators in that regard, and then brought the prosecutor back in again in a more private environment to say, this is what we're finding. And just like Jeff's saying, it's not anything that the prosecutor did himself, but that in the end, after we presented the situation to him, he could understand the decision was going to be made.
Okay, I see. Let's go right there.
The question that I have is regarding the proliferation of video evidence and its relevance in more and more cases. What your thoughts are, and whether your office has specific policies regarding having witnesses view that portion of the event that they were present for on video before participating in a ID process.
Well, for me, it depends on whether it's a civilian or a police officer witness. So with for police officer witnesses, our position is that they can view their recorder if it's from whatever perspective, if it's on their body, that they could view it, but not the audio. And the only reason for that is there may be other dialogues going on or other discussions that they were not part of, but that gets captured on a tape. I mean, part of the reason to record is to make sure we accurately capture what's going on. And, you know, we wouldn't throw a police officer or a witness on the stand without pre-trying him. And so I don't want to set someone up to have a failed memory or mistaken memory about order. And I mean, I was a sexual assault prosecutor for years before I became an administrator, and it was very not uncommon for people to remember the orders differently, to remember incidents differently as your mind lets certain things in. So to the extent that it was used to refresh the officer's recollection of what happened, then I want them to be accurate. And you know, if they write a report, I mean, nowadays we don't have that many written reports anymore. Almost everything is, I mean, in terms of narratives, almost everything is done through the recorder. And so it changes the whole dynamic in terms of capturing what a witness said and, you know, like the game of telephone, redefining it in the witness's statements versus having a recording of that.
So your question encompasses a number of different scenarios. So in our county, in terms of officers reviewing video or audio, because a lot of the officers are wearing cameras. For departments where the officers have been wearing cameras for years, this is really second nature to them. They're not taking notes anymore. They're going back, when they write their reports, they've got it on audio or videotape, and they're summarizing that. The only situation where we don't want an officer to look at the tape or look at the video before making at least an initial statement is in an officer-involved shooting situation where the officer shot and killed someone in the line of duty. In situations like that, we'd like the officer to first give a statement, and then the investigators looking at that, investigating whether the officer committed a crime, may in their discretion want to go back and have the officer look at the tape and ask some additional questions. Sometimes that happens. But we'd like that, because someone's been killed in that situation, we'd like first to just have a statement from the officer. In the situations you're talking about in terms of witnesses, it really depends on what the situation is as to whether or not the investigator is going to have the witness look at the statement first, look at the video first. It's true what you say, almost everything is on video now. It's incredible. And part of the impetus for officers in our county to wear cameras, because there's some legitimate concerns that officers have about wearing video cameras recording their interactions with people all the time. I mean, you wouldn't feel comfortable if you had a video camera on recording all of your interactions. I imagine sometimes you might be a little bit rude or not so nice to people. But part of the, or maybe not, you're perfect. But part of the impetus for the officers to wear these is, one of the things I said to them is, when you're involved in a situation on the street, very quickly, that's going to be recorded. If there's either a bank video or a liquor store video, or somebody has a home video camera that's looking out onto the street, or quickly people will come out with their cell phones. So you may as well have a camera that's recording things from your perspective as opposed to these other perspectives.
Okay, let's go in front here. Oh, okay, right here first, and then we'll go there.
Do your protocols extend to physical lineups, in-person lineups, these practices of sequential showing and blind administrators?
In my county, they do.
We do very few physical show-ups in our county. I would say more than 90%, 95%, it's a photo lineup. So in terms of, I mean, it's much more interesting television to have people walk in and do the lineup that way, but it's very expensive and time-consuming to do that, and it's much, with computers and laptops, it's much quicker to get filler photos and DMV photos to do these things with photos. So, but in terms of if we do a physical lineup, the same principles would apply.
Okay, just wait for a mic and then, thank you.
It's pretty much the same question except having to do with in-field show-ups. Do you have any protocols or any ideas about your feelings about in-field show-ups, which happen right there at the scene?
There are in-field show-ups that we do in our county, and I know that some feel we shouldn't do these at all. And my response to that is there are often situations where this is the investigative lead that we have now, and when I say now, I mean right now. I don't mean in 2 hours or 2.5 hours. I mean this is what we need to find out right now. So we do them, and again, it's one piece of a criminal case. I think there's some sense from all of our discussion about eyewitness identification that we have all these cases going to trial where the only evidence is an eyewitness's identification. I actually think that's a very rare situation when that's the only piece of evidence. And certainly in any kind of criminal case as a prosecutor, if we only have one piece, one type of evidence, DNA, whether it's DNA or blood or an eyewitness ID or motive or a bank statement or whatever it is, we'd like to have more than one piece of evidence. It strengthens the case, and we like to have different kinds of evidence. So yes, we do in-field show-ups.
And we do as well, and for the same reasons that Jeff just described. I mean, they're pretty immediate. They're close in time to the actual reporting of the crime, and an infield show-up doesn't really lend itself to a process like this.
Okay, let's go hand in the back there.
Hi, I was just wondering, Ms. O'Malley spoke to this, but Mr. Rosen, how many, are all of the agencies in your jurisdiction practicing these best practices, and are they applying these best practices for both of your counties to all cases, even misdemeanor investigations? And then just a second question was, in how many lineups does the suspect actually not appear in the initial lineup that a witness is given? You said that sometimes they're always admonished that person may or may not appear. Does that ever actually happen?
So I actually think you asked 3 questions, but I'll try to answer all of them. So in our county, there are 13 law enforcement agencies within our county, and all 13 do double-blind sequential photo lineups and have been doing so since 2002, and they do that on all their cases. They don't differentiate between a misdemeanor or a felony case. You know, now having said that, to be candid, I don't know that, well, I know that it hasn't happened 100% of the time, that there have been a couple occasions where this particular protocol wasn't followed as closely as we would have liked. Just like I'm sure in any field, there's not 100% compliance with whatever the standards are. And in situations like that where it's come to my attention or come to our prosecutor's attention that this protocol wasn't followed or they didn't get a second officer to do the lineup, you know, we inquired and talked to the lieutenants and the captains and the chief and just encouraged them that this is as to why it was important to do that. As to your question about the number of times that the suspect is not in the photo, I think I'm not quite understanding it, because the way I hear that is we're not just showing lineups for fun. Do you know what I mean? Like we're not just picking 6 random people and saying, do you see the person that robbed you in this photo? There's always someone in the photo that we think is a suspect in the case. That's why they're in there. So maybe I didn't understand quite.
I guess I'm wondering if maybe you would say that you're going to show them 2 different lineups, and one that either or may not include a suspect in this case, so that they know that there's some assurance that the person that they remember in their mind might really not appear in this lineup. Perhaps it's going to appear in a lineup that I do 5 minutes from now.
Oh. I don't think we do that. I'd say that when we have situations where there are multiple individuals involved in a crime, you know, let's say there's 3 people that attack someone, we don't put the 3 suspects in the same photo lineup. There's 3 separate photo lineups there's a separate photo lineup for each of those 3.
And I think also what you're asking is that we do have photo lineups, of course, but we really would rather have live lineups. So I think what you were saying was that, do we ever do it sort of as a quality assurance that the person is really picking the right person? So you put one fake lineup together and then a real lineup after? We don't do that.
Over here to the left.
You guys spoke on letting police officers look at video prior to identification or written reports. What's your guys' view on, like, victims? If a victim was robbed, the robbery's captured on video, letting them view the video of the robbery prior to doing like a photo lineup?
So if it's on video, then I don't really need the lineup, because I have the better evidence, which is the real video. And I think also that if there's a forensic or evidentiary value in showing a witness or the victim a video of the crime, then there has to be a reason for that. But just to show it to them re-traumatizes people, and if there's no value in it, If there's nothing that, there's no question that's hanging out there, then I wouldn't show them that.
Jeff agrees. In the front here.
I'm just wondering if there is a maybe a sea change coming among district attorneys and police officer or police agencies based on what you've seen, that maybe some of us in counties 80, 90 miles from here might be hopeful that other district attorneys and police agencies might be catching on to this?
The answer is yes. I do think it's coming. It's not coming maybe as quickly as some people would like, but I think it is coming. Within the Bay Area, really, I mean, you have the three major counties, the three major population centers between San Jose, Oakland, and San Francisco, and those counties where this is all being done. I know that the DA in Contra Costa County, Mark Peterson, is looking very closely at this, and I'm optimistic that they're going to adopt it there as well. He's looking at it. I think that there's been, for reasons that I don't fully understand, I think that the progress has been quicker here in Northern California and slower in Southern California. I've reached out to the elected district attorneys in San Diego and Orange and Los Angeles County, and I just don't think they're there yet. I mean, I've spoken a number of times with them about it, and they're looking at it, and maybe it's not the same priority for them, or they have other reasons. You know, I want to be persistent, but not a nudge. So I think it's slowly coming, and I think part of what the conversation I've with other elected DAs, I don't want there to be legislation legislating us to do this. I think it's better if we choose to do it ourselves, and I think that we'll get better. I think that just is a better result, and I am concerned that that there is going to be legislation that's going to mandate certain policies, and you know, it's not going to affect my office, and it's not going to affect Nancy's or George's because we're doing this, but I think it would be better if they came to it on their own.
So I know that our executive director from the California District Attorney Association is actually here, and these are conversations that we have and have been having. And I think that some of the challenges for some of the smaller counties is that, you know, there's some counties where there are only a handful of police officers, and they all know what's going on. So to find a blind administrator, you're sort of setting them up to never be able to comply with the protocol. And that's a challenge that people are trying to work through. How do you address that? How do you find someone who hasn't heard through the grapevine what the major crime that just happened in their little county just was? And so I think that there are some practical considerations that exist around adhering. We have the benefit of having multiple agencies and larger agencies and, you know, shifts where people don't know what happened on the night shift the next morning, that kind of thing. And so, but I don't want to, I mean, I think that the evaluation of this as a practice, as a best practice, and the discussions points that are going on amongst district attorneys is happening. And I know it's also happening amongst sheriffs and municipal police agencies, because they're, you know, I don't think it's part of the POST curriculum yet. I think POST is still teaching the simultaneous lineup as part of their training, but I think that we see some of the other major law enforcement agencies that are providing training like this for law enforcement.
Great.
I've got a question here.
Oh, okay, go ahead.
Thank you. With respect to the cases that you look at retrospectively, how do you decide which cases you're actually going to review? And is that a different procedure at each of your offices? And then my next question is, on your reviewing teams, do you have any procedures in place to actually review cases that are going to trial on the issues that might be infirm with respect to Eyewitness ID? Or is this all just, at this point, trying to implement best practices and then just doing a retrospective analysis?
we review all the cases that retrospectively, like if somebody writes me a letter and says, yeah, I'm sitting here in prison and I didn't do it, and here's my case number, and yes, there's been, you know, the conviction's been upheld by different appellate courts, doesn't matter. I give that to our conviction integrity unit to look at and to reinvestigate as appropriate. And the level of reinvestigation depends on the case. I mean, sometimes it's talking to witnesses again, talking to other witnesses. Sometimes it's often a request to have something tested from the crime scene for DNA evidence, and the ability for us to gather DNA from crime scenes and to test more and more specifically for DNA has gotten better and better. So it's often a request to retest something, and we're very open to doing that. Sometimes it's a request from the Innocence Project or some defense attorney that's representing them, and we do that. So we look at all of them. Now, in terms of cases that are heading to trial, there's pretty thorough review that's happened at that point. I mean, every prosecutor in the office has a supervisor and a person over that supervisor that are looking at cases carefully before they go to trial. We're very, very careful about a case that's going to trial. Frankly, not even just a case, about issuing a case where the only piece of evidence is an eyewitness identification, because we've gotten burned on that before, and we don't want it to happen again. So we're very, very, that case gets a lot of scrutiny before it's issued or goes to trial. The other area is we're very cautious about using informants, particularly informants that are in jail, and because, you know, we understand that there's risks with that. So I think that the protocol there is very cautious, very hesitant about going forward, either where a significant piece of evidence is an informant that we're relying on, or this case is all eyewitness ID.
You know, I would answer pretty much the same. The only other part that I would add to that is that if it comes to our attention through our Brady committee or some other way that we receive information about a particular officer, that will trigger us to go back and look at other cases if we're going retrospective. And just like Jeff said, in my office there, I have 11 branch offices, so cases that originate in one are not necessarily going to trial in that same branch, and different teams have their hands on the case. So we have different people that are looking at it from a evaluation for filing charges, pre-trial, putting on a preliminary hearing, preparing it for trial, and all of the process again. So if somebody has an alert, then we will take a look at it. And by someone, I don't mean just the lawyers. If one of the investigators is talking to a witness or something triggers something, then they can bring it to our attention. And then oftentimes we'll hear from the defense lawyer